Ms. Wood?
Thank you, Your Honor. We're present in case State of Ohio versus James Kidd, case number 25 CR 275. The defendant is present today in court represented by attorney Rachel Smith. We are also present in court on case number 24 CR 681 and 23 CR 1235. There were probation violations filed on those cases. You were previously in court May 6. On the 25 case number, the defendant pled guilty to count 1, failure to comply, a felony of the 3rd degree, count 2, possession of cocaine, a felony of the 5th degree, and a lesser included offense, count 3, unauthorized use of a motor vehicle, a misdemeanor of the 1st degree. This matter was then referred for an updated pre-sentence report and victim impact statement, and we are scheduled for sentencing here today. Thank you.
All right, on 23 and 24, we got the final hearing on the probation violations. First violation, failed to contact probation officer since December 2 of 24. Do you understand that charge?
Yes, Your Honor.
Second, negatively discharged from the Veterans Affairs Transitional Residence Program December 9th of 24. Do you understand that charge?
Yes, Your Honor.
Third, arrested by Willowick PD, charge of failure to comply, which I believe is the 25 case, February 25. You understand that charge?
Yes, Your Honor.
And on February 25, driving while under a lifetime suspension. You understand that charge?
Yes, Your Honor.
Ms. Smith, what does he want to do with regard to his final hearing?
Your Honor, it's my understanding that Mr. Kidd at this time does intend to waive his final hearing, plead guilty to the alleged probation violations, and would save his sentencing arguments for the primary case.
Is that what you want to do, Mr. Kidd?
Yes, Your Honor.
What's your plea to those violations?
Guilty, Your Honor.
I'll accept your guilty plea and find you guilty. Ms. Smith?
Thank you, Your Honor. On behalf of Mr. Kidd, prior to coming to court today, I did have an opportunity to review the pre-sentence report that was prepared in this matter. I did not notice any inaccuracies or anything inconsistent with what I've had the opportunity to learn about Mr. Kidd over the last year. Your Honor, Mr. Kidd is 62 years old, an Army veteran. He does have service-connected PTSD with military sexual trauma. Additionally, he has been addicted to crack cocaine for a number of decades. That is what brings Mr. Kidd before the court today. His criminal conduct arises from his drug addiction, and it's his belief that his drug addiction, in some part at least, arises from his trauma history. We are asking the court, despite his probation violations and new case, to give him one more opportunity at residential treatment. Mr. Kidd has attempted residential treatment locally in the past with very little success. However, we have been able to arrange admission for him, should the court permit, at the Bath Domiciliary Residential Rehabilitation Program in Bath, New York. Not only does it address, it's not just a short-term rehab center, but they address recovery, rehabilitation, health maintenance, improved quality of life, and community integration, in addition to specific treatment of medical conditions, mental illnesses, addictive disorders, and homelessness. And Mr. Kidd does not just suffer from a substance use disorder. He has a number of afflictions listed there. It is our belief that if Mr. Kidd is ever going to kick his addiction, that this may be his best opportunity. He has expressed what I believe is a sincere desire to do that. And so we are asking the court to place him on community control, with one condition being that he complete successfully treatment and the program in Bath, New York.
Thank you, Mr. Kidd. What do you want to tell me?
First of all, Your Honor, I'd like to apologize to you, your court, and all the officers and everybody involved in this case for my horrendous choice of judgment. Your Honor, I was clean for 7 months whenever you placed me on probation. I just wasn't equipped to deal with all the things that was going to come with me being clean, that I kept the MST by being raped when I was in the service, by an NCO, that I kept buried for 40 years or so, Your Honor. I wasn't prepared for how to handle that, how to talk to people, because then it brought it back up that somebody that in charge of me or in charge of my life that I was entrusting my life to did that to me. So now I got to entrust my life to somebody else and how to deal with that. So what do they want out of me or what or to that nature? So I wasn't prepared properly to deal with that. And with the accident that I had that caused it to somebody, that all came back up to the surface. I just wasn't prepared for that, and I fell back into getting high, Your Honor. And I beg this court to please give me one more chance, man, to send me to Bath, New York and help me kick this addiction. I'm 62 years old, Your Honor. The last place I'm in, everybody's got to die. The last place I want to die is in a prison. And if I mess this up, Your Honor, then I deserve everything that you throw at me.
You were sentenced on August 6th for failure to comply. I think one of the top speeds that they had you going was 106, 60 down 271, I believe. As a result of that, you were put on probation. Released to the VA Inpatient Clinical Dual Diagnosis Program. Went there the next day. And you were discharged negatively on December 9th. Why?
That is the one number, I was at the TR house at that time, Your Honor. I had done completed the domiciliary program, and they sent me to the sober living house.
Right? Why were you discharged?
Because I went out on the pass, Your Honor, and like I said, at that time I had came in front of you, I lost my vehicle and all that stuff, and didn't know. I ended up getting high, Your Honor. That's what happened.
Okay.
That's exactly what happened.
Okay. This record goes back 43 years now to West Virginia, then Cleveland, and in August of '86, aggravated vehicular homicide. Went to prison for about 4.5 years. Driver's license permanently revoked.
Yes, sir.
Get out in October '91. Within a year, you got a weapons under disability. Go back to prison for, sentence was 18 months to 5 years. And you served 1 month short of 5 years, got out in '98. Another felony in '05 in Lake County, forgery, possession of cocaine. Misdemeanor drug charges. Relatively quiet from when you get out of prison till 19 is your 22 is your next felony. So you got a bunch of misdemeanors, a lot of drugs, obstructions, falsifications, thefts, all misdemeanors though. So your activity did not cease, and you get this cocaine possession in the 23 case. 5/7 of 24, you pick up the failure to comply, the first one. I don't know why were you driving when your license was permanently revoked?
I had no reason to be driving whatsoever, Your
I
Honor.
don't know what, I know that, but
Yeah.
why were you driving?
I was high.
Okay. I sentenced you on 8/6 of 24. October 16th of 24, you get a driving under suspension in Menor. I mean, I must be a goddamn idiot.
No, you're not, John. I am.
2/6 of 25, you get this thing. What were the circumstances of this one?
I was going to get dope, Your Honor. The cop of the
Whose car was it?
Danielle's, a girl that my sister lived with.
Did she let you use the car?
Yes, Your Honor.
So you asked her to use the car and she gave you the keys?
The keys, I had the keys to her friend. Came up there and said that she had just got the car and she told she wanted me to go vacuum the car out. I was going to go trying to get some dope anyway, so I told her I would. Well, that was her friend. So when Danielle ordered for me to keep Danielle out of trouble and not get her license involved in it, I pled guilty to the driving her vehicle or having a vehicle without her permission to keep her out of trouble.
Well, that was the Painesville one. I'm talking about this one here.
That's what I'm talking about.
Well, you're confusing me because there's so many of them.
No, it's
Whose
this
car-
last
whose
this
car
last
we-
one was Danielle Murdoch's.
Was that a rental car or was it her
Yeah.
car?
A rental, I guess, or hers, or one. I don't. Yeah, it's her vehicle. That's the only vehicle that was her. That I think. The other vehicle that I got to driving in the mirror was my vehicle.
Where'd you get a vehicle? You don't have a license since
I bought a
1986.
vehicle. I bought. Whenever I came up in front of you on the violation, when I got pulled over a minute for driving, when I came into court here, I explained that my sister I let my ex-wife, the lady I was with for 20 years. When I was up here in jail waiting on my first case, she came up here and she said she was tired of walking. I told her that I would let her have my vehicle. That was this other case. That's when I got violated. To let her use my vehicle until I got out and got my business going again and got a driver. Well, whenever I got out and went to the domiciliary and of that nature, and I got everything going, I started back my business, my painting business. When I came, I had my sister with me to go get my vehicle. She's a licensed driver and insured to get my vehicle. And I told my ex-old lady that, hey man, I need my vehicle. I got a job to do. I got a painting job to do. And she told me that that was her vehicle and I would give my vehicle back. And at that point in time, Your Honor, I wasn't hearing it. I did a favor for her and paid $3,000 for that vehicle and let her use it so she could run around with her grandkids, help her grandkids and everything. And out of the kindness of my heart did that for her. And then she wanted to try to take my vehicle away, that I had bought and paid for, that she didn't pay one red cent for.
My problem with you is not, if this were a situation where you got, your 24 case was a drug case, and the 25 were a drug case, because you couldn't stop using drugs, that's one thing. Okay? You've got an aggravated vehicular homicide, and here we are, 35 years later, you're leading the cops on a chase at high rates of speed, putting yourself, putting them, and other people just going to the store in danger. Now, I made a mistake because I put you on probation after that death case 40 years ago, and you're doing the same thing again. So you aren't, just using drugs. You're using drugs and getting in a car and exceeding 100 miles an hour, leading on another chase, putting yourself in danger, putting the police in danger, and putting Bob Smith in danger just driving down the road. That's what you're doing. So it's not a matter of you just committing drug possession offenses. Everybody commits drug possession offenses. I don't think I've had a case I don't think I've had a dozen cases in 10.5 years where it's been, where drugs haven't been involved. Okay, but you're going way over the line, putting all kinds of people in danger. And nothing I do changes anything.
I realize that.
Mm.
I know I know that I'm the only one who can change that, Your Honor. I mean, and I apologize sincerely for that. I don't know. I mean, I'm trying to get the help that I need. I don't.
Well, you get the help that you need, you just don't take advantage of the help that you get. That's what it is. That's what it is. Ms. Wood?
Thank you, Your Honor. The 2025 case that we're here for sentencing on, as outlined in the police report and the pre-sentence report, was a chase involving the Sheriff's Department all through the entire county into Cuyahoga County. Speeds were around 60, but then slowly increased to around over 100 miles per hour. The defendant did not stop his vehicle. His vehicle had to be stopped by the police. There were 2 flat tires. He was driving on the rim, and when he was arrested, there were drugs in the car. He not only put himself at risk of physical harm, but the officers pursuing him, the officers trying to lay the spike strips on the vehicle to stop the car, and all the other people who were driving on the freeway at the time. The defendant has served prior prison sentences dating back to 1987. There's been a rehabilitation failure. He's been on community control, not only to this court most recently, but back when Judge Collins was here, as well as other municipal courts. He has violated probation in the past, and he violated probation while he was on to this honorable court. He has a drug and alcohol issue, and he has been given the treatment opportunities before at the VA, and he did not successfully complete and take advantage of those opportunities that were presented to him. The vehicle in question here was a rental vehicle by Danielle Murniak from Enterprise. Both or either of them have suffered economic harm. Danielle reported to the victim advocate that Enterprise sent her a bill for $9,600. And my understanding is that Enterprise submitted a victim impact statement for $9,228.90, specifying that the value of the car is over $8,400. The vehicle was damaged here. It had to be towed and repaired before it could even be thought of being put back into service. So the state is asking for restitution in this case. The state is recommending prison. I don't think that the defendant would be a good candidate for community control. He's put himself and others at risk by getting behind the wheel, given his current history, not having a valid license, and also that he admitted involving drugs, impairing himself, posing a risk of harm and danger to others. So in the 2025 case, the failure to comply, the state is recommending 18 months consecutive to 6 months on count 2. The state is recommending that all of his cases be run, well, by law, the failure to comply has to be run consecutive, 6 months on the 23 case number, and 12 months on the 24 case number, all consecutive for a total of 42 months in prison, with credit for time that he has served in the Lake County Jail that we did discuss in chambers. Thank you.
So the only restitution is on the 25 case?
Yes.
9228 what?
90.
So why did Enterprise, any idea why Enterprise sent a bill to Ms. Murniak for $9,600?
I don't know, Your Honor.
Ms. Sweeney, any idea?
I I believe from our conversations with her, Ms. Wood and myself, she did not elect to get insurance on the vehicle when she rented it, so I believe they were saying she was liable for whatever damage.
Okay.
That's my recollection.
All right, I've gone back and reviewed the,
Your Honor.
yeah,
I'm sorry, before the
Yeah.
court proceeds to sentencing, Frank DeMario from the VA is here and wanted to address the court on Mr. Kidd's behalf.
okay. Go ahead.
Yeah, Frank DeMario, DeMario. I'm a retired federal agent, retired supervisor in Lake County Narcotics. I've dealt with the defendant for the past couple of years of my visits to the jail. He always presents a positive outlook at things, but he continues, just like you said, to go back to using crack cocaine. But my only hope was that he'd go to Bath, New York, which is probably one of the best in the United States drug rehab. And we read I understand. It's a tough decision, but if you see it possible, I would definitely love to see it go.
All right, thank you. Ms. Wood, what did you, on sentencing on the 23, what was your recommendation on the 23 case?
On the 23 case, my recommendation is 6 months.
All right, I've reviewed all three pre-sentence report, the two pre-sentence report involving all three cases. I've considered what Mr. DeMario has had to say, Mr. Kidd, and counsel. I've considered all the provisions in 29-29-11, 29-29-12, and 29-29-13. Your as I said, Mr. Kidd, your problem is not it's not just the use of drugs. It's what you do resulting from the use of drugs. You've indicated clearly that you cannot contain your activities, which leads to putting everybody in danger that happens to be out there when you're out there. So I'm going to find you're not amenable to community control. On the 23 case, on this probation violation, I'm going to sentence you to 68 days in a Lake County jail with credit for 68, terminate your community control. On the 24 case, I'm going to sentence you to 18 months in prison with credit for 183 days served. The 25 case on count 1, I'm going to sentence you to 18 months in prison. On count 2, 6 months in prison. Those by statute are consecutive to one another. Count 3, 180 days in jail concurrent with credit for 106 days total. The 24 and 25 cases are by statute consecutive to one another. Restitution, the amount of $9,228 to Enterprise and/or Ms. Murniak, not both. The court costs are assessed in each case. When you are released, you may be on post-release control for up to 2 years under the parole authority with conditions. If you violate the conditions, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. If that violation is a new felony, then you could get an additional consecutive prison sentence for that violation, the maximum of which would be the greater of 12 months or the time left under post-release control. Is there anything further, Ms. Wood?
Because the defendant pled to failure to comply and has a prior failure to comply.
Permanent driver's
Permanent.
license suspension.
Yes, thank you.
Again, for the third time. Anything beyond that?
I don't think so, Your Honor.
Ms. Smith, anything?
Nothing additional, Your Honor.